All right, so this one, another background reading, How to Read a Legal Opinion by Uren Esker. This was a good one. I'm just going to show you guys kind of what I highlighted and what I thought was important because this gives you a roadmap to head into before, while you're reading your case. So first, it starts off with what's a legal opinion. It's essentially how the judge comes to concluding a case in a dispute. Now, first thing you want to know is the caption. It just kind of tells you what the name is. Not too much there. You kind of just want to know where your case is coming from and who's suing who, essentially. Citation is pretty much how you find it in a book, how you look it up. Then it goes to the author. Fun fact, all the names are going to start with a J, but that's not for, their first name. That's for judge or justice. So don't let that throw you. But here, they get into the facts of the case. This is the important part because that's kind of where they're going to base their reasoning on. And after the facts, include is the procedural history, pretty much what happened in the past that led to this. But this is a contracts class, and I really like here that they pointed out that it's less important for, contracts and criminal law for those classes. However, in your civil procedure class, which is another one we're going to do later, procedural history is the most important because, civil procedure. But for here, you can kind of not give it as much importance because we're not concerned on that. And then it goes into the law of the case, and then it will discuss the law. And it comes in two stages. If there's any kind of sequence, I use blue to kind of link them so I know what's in between. But the first stage, they go over the general principles of the laws that are relevant to the case. And it gives you the background. And then the next part is a second stage where the particular facts of the dispute are discussed. And this is going to be the heart of the opinion. So they're going to give you the background facts and what happened before, and then they're going to give you how it relates to this particular dispute. And that's where your main reasoning is going to come. And then after that, you have your concurring and dissenting opinions. All that means is these are multiple judges who are coming up with a conclusion for these cases. So some either agree, concur, or dissent. But the majority is how the law is going to be held. So the dissenting opinions are also important because for future purposes, some problems are spotted but not fixed until a later date. And then it goes over common legal terms that are found. I kind of skimmed through this one because it was kind of relevant or obvious, like where word plaintiff comes from and defendant. I didn't really find much importance in that section, so I moved on. I did highlight here that most opinions are appellate opinions, so that's just kind of give you a broad sense that most of your issues are going to be coming from trial court proceedings that the defendant or believe there was a problem with. And then goes to how to read a legal opinion. And then here we get into the most important, what you need to learn from reading the case. So you need to know the facts. I wouldn't say memorize them, but you need to just kind of have an understanding of them so that you can know how the reasoning of the judge worked. So know the facts. And then the specific legal arguments made by the parties. And there will be two parties, so you'll need to understand what the two sides were making, because of course they're going to be disputing each other in front of the judge. And then you want to know the disposition, which is the action. This is going to come at your very end. You want to know what the court decided. Did they agree with the lower court's decision? Did they vacate it to a different court? Did they wipe it? Was it reversed? All those different terms are in that section. And then you want to understand the reasoning of the majority opinion. I think this is the key point that you want to get from reading your case, the reasoning. They also throw in here that most of it comes from the common law as opposed to statutes. And I highlighted here that after you identify the source of law, you should next identify the method of reasoning that the court is using to justify its decision. It's very important. Yep. In dicta, they just also put in there, I highlighted it red because I'm not really, it's one of those new terms for me, but it's just the opinions that are not needed to resolve the dispute, but they're kind of there anyway. It's like partial conclusions, I'm imagining. And then the next, they announce the holding. That is pretty much the conclusion, what's going to be the new rule, and it's very important that you get clear grasp of what the holding is, although sometimes it is very vague, so you have to imagine what the holding could be, because in class they're going to give you a lot of different situations and hypotheticals testing that holding and see if it will hold if one or two of the facts were slightly changed. So that's kind of how you practice. And I highlighted that here. You can ask the hypotheticals on your own before class to kind of get a sense of how well you understand the holding. And that's a key point. And then it goes into how to read the legal opinion. And then it talks about the history of why the law professors use the case method. And that's all I got from this reading because it ends there. But essentially it says you gotta have a vivid imagination.